friends. I'm Jeffrey Rosen, President and CEO of the National Constitution Center, and welcome to We the People, a weekly show of constitutional debate. The National Constitution Center is a nonpartisan nonprofit chartered by Congress to increase awareness and understanding of the Constitution among the American people. Friends, before we start today's episode, I'm thrilled to share that we've been working on a new podcast series, which is out next week. It's called Pursuit, The Founder's Guide to Happiness. Here's the trailer. Walk with me through Philadelphia in the 18th century. Blacksmiths hammering metal outside their shops. Men drinking in taverns and trading gossip in the streets. Ships docking at busy ports. Cries for liberty that would lead to the American Revolution. And the voices of Ben Franklin, John Adams, Thomas Jefferson, and others whose debates, convictions, and compromises helped shape a nation. But long before Jefferson included the famous phrase about the pursuit of happiness in the Declaration of Independence, he and the other founders were struggling to pursue happiness in their own lives.
Ben Franklin devises in his notebook a beautiful means of keeping track of conquering each of his faults, of hewing to each of these virtues on a weekly basis.
In his early 20s, Franklin had been reading classical Greek and Roman philosophers like Pythagoras, Plutarch, and Cicero, and scanning popular magazines for advice to print in the Pennsylvania Gazette. Based on his reading, he concluded that the secret to self-improvement was self-examination.
Our founders were realists. They knew a thing or two about the good parts of human nature and also the worrying and bad parts of human nature.
The pursuit of happiness, they believed, wasn't about feeling good, it was about being good. And the reason it was a pursuit? It was something you had to work on for life. I'm Jeffrey Rosen, President and CEO of the National Constitution Center. In each episode of Pursuit, The Founder's Guide to Happiness, I'm joined by a leading historian of American history and by the award-winning filmmaker, Ken Burns.
Heretofore, in the history of human beings, they have been subjects under the authoritarian rule. We're proposing something altogether new called a citizen. And in order to be a citizen, you have to be virtuous.
The founders were far from perfect. At times, they've shamefully betrayed the ideals they set for themselves. But all of them agreed that the key to a healthy republic begins with how we commit to becoming better people over time. In fact, John Adams
continued to learn, to read, to seek out new information. He was quite interested in learning about new cultures and places and foods and religions and ways of life. His diaries until the end of his life will discuss his farming during the day and then what he was reading at night.
As we explore their wisdom and confront their flaws, we can find keys to a deeper, more meaningful happiness today. Ken Burns will share his own project of reading and self-reflection that he's practiced daily for the past 10 years.
Like, we always want something. We want peace, we want inner tranquility, we want the new refrigerator, we want the new car, the new clothes. But actually, it's the giving up of that that creates the space for there to be the kind of environment for real work to begin.
Join me for Pursuit, The Founder's Guide to Happiness from the National Constitution Center and PRX Productions. We'll focus on one founder a week and one of Benjamin Franklin's virtues, starting September 8th. Listen to Pursuit, The Founder's Guide to Happiness on your favorite podcast app. On August 25th, President Trump announced his decision to fire Lisa Cook from the Federal Reserve's Board of Governors. This week, we'll discuss Lisa Cook's termination and the broader legal and constitutional issues it raises, including the scope of the president's removal power and the history and constitutionality of the Federal Reserve. To help us unpack these topics, I'm honored to convene two of the leading scholars on executive power and the Federal Reserve. Christine Chabot is professor of law at Marquette University, specializing in constitutional and administrative law. She's written a series of important articles challenging the historical and originalist argument for the unitary executive theory, especially as applied to the Fed. Christine, it's wonderful to welcome you to We the People.
Well, thank you for the invitation, and I look forward to the conversation with you and Michael.
Wonderful. And Michael McConnell is Richard and Frances Mallory Professor and Faculty Director of the Constitutional Law Center at Stanford Law School. Before that, he served as a judge on the 10th Circuit. He's the author of several important books and articles on executive power, as We the People listeners know, including The President Who Would Not Be King, Executive Power Under the Constitution. Michael, it's always wonderful to welcome you back to We the People.
Thanks for inviting me, Jeff.
Let's begin with the broad question. Christine, what is the constitutional structure of the Federal Reserve? And in your view, is it consistent with the Constitution or not?
Yes, so I think the key question about the Fed's structure is its independence from political control. And according to Unitary executive theory, the president should have power to control all subordinate officers by being able to fire them at will. And the problem is that the leadership of the Federal Reserve, the governors, are protected from removal because they can be removed only for cause. So that's an impediment to the president controlling their policy decisions. And by design, the part of the role of the Fed is to effectuate two goals. It wants to, Congress has directed it to ensure maximum employment and stable prices over the long term. And often presidents would prefer that the Federal Reserve think about the economy over the short term or maybe take actions to heat up or juice up the economy. And the statute tells the Federal Reserve to push back against that immediate political pressure and take a longer term view. And that is why it has those for-cause removal protections that allow it to be politically independent in following its statutory mandate.
Thank you so much for that. Michael, what would you add to the structure of the Federal Reserve? Are its for-cause removal requirements different from that of other administrative agencies or not? And do you believe it's consistent with the Constitution?
So just two complications. The Federal Reserve is actually, I think, one of the most complex institutions in the entire government. So within the Fed, not only is there a board of governors that Professor Chabot was talking about. That's a 7-person board. And as she says, with 14-year staggered terms protected. But there are also 5, there are actually 12 regional banks, and there are 5 of them at any given time are represented on the Federal Open Market Committee, which is the committee that actually makes the most important central bank decisions. And these Federal Reserve banks are not appointed by the president at all. It's a complicated system, but it's fair to say at least a major portion of the ability to appoint them is private, that is coming from member banks. It's more complicated than that, but that's all we really need to know here. And so that portion of the Fed is even more peculiar. And then one other thing I think it's important to stress is that while we think of the Fed's central bank functions as being what they do, and they are by far the most important thing, and they are the thing that causes so many of us to be alarmed at the loss of independence, is those central bank functions, which have to do with the setting of interest rates and thereby really controlling inflation and the economy. But the Fed over time has been assigned a number of other functions which are more directly regulatory in nature, including various consumer protection laws and bank reserve laws and others. Now, these are not central bank functions. They are regulatory functions. They are your typical command and control regulation where, the agency announces what they have to do and people, the regulated parties, have to do it, and they're punished if they don't. That's in contrast to the central bank operations, which are not command and control, and which consist of this Federal Open Market Committee buying and selling securities on the open market and lending money to banks at interest rates which they set. Now, those are not command and control. Those are those are market participation functions that, because of the size of the Fed, can dominate the setting of interest rates. And it's my position, we'll talk about this in more detail, I'm sure, down the road, that the unitary executive principles of the Constitution require that the president be in control of the regulatory functions of the Fed, but not the central bank functions of the Fed.
Thank you so much for explaining that so clearly and drawing that distinction between the regulatory and central bank functions. Well, let's turn to the question of constitutionality. Christine, in an important article in the Notre Dame Law Review, you've laid out a powerful originalist argument for the constitutionality of the Federal Reserve's Open Market Committee. You say that it has a strong historical analog in the Sinking Fund Commission, proposed by Alexander Hamilton, passed by the first Congress, and signed by Washington. Tell us about the Sinking Fund Commission and why you think it's a good precedent in favor of the constitutionality of the Fed.
Yes, happy to walk through more about the Sinking Fund Commission, which I think is a crucial historical counterexample to originalist arguments for a unitary executive. So this was really Alexander Hamilton's brainchild. He wanted to figure out a structure that would be a reliable way for the government to pay down the debt and ensure that the government actors entrusted with large sums of money for this purpose would actually spend them on the debt rather than some other more politically attractive goal, like lowering taxes or that sort of goal. So to do so, he proposed an independent commission, and Congress went along with his proposal. They adopted the Sinking Fund, and it really has an all-star originalist cast. It had Chief Justice John Jay. It had the Vice President John Adams. It had the Secretary of the Treasury, Alexander Hamilton. It had the Secretary of State, Thomas Jefferson, so he and Hamilton did not get along so well. And the final member of the Sinking Fund was Attorney General Edmund Randolph. So this 5-member commission was entrusted with the job of approving payments that would be used to pay down the debt in the form of open market purchases. And 2 of its members were independent of the president. They could not be removed by the president because they were placed on the commission ex officio, the Chief Justice and the Vice President. So they voted independently on these executive decisions. And just to qualify slightly, I know Michael had mentioned before the idea that maybe monetary policy conducted by the Fed, which also historically has been conducted through open market purchases, maybe that's somewhat different than some of the other executive functions, but I think it still counts as executive power. And I think what the Sinking Fund Commission did in pursuing its statutory goals, which were to pay down the debt while maintaining U.S. credit, I think that action was as well executive power that was being exercised outside of the direct control of the president. And that's a reason why it's okay for the Federal Reserve to also have the members of the FOMC, which consist of both the governors of the Federal Reserve as well as 5 participants from the regional banks. It's all right to have independence on that body setting monetary policy as well.
Michael, I know Christine, of course, is the expert on the history of the Sinking Fund, but what is your response to her claim that it was independent because if Congress had wanted it to be under the direct control of the president, it wouldn't have required the president to approve purchases authored by a majority of the commission. It wouldn't have even bothered with a multi-member commission at all. And it wouldn't have deferred to Hamilton's clear desire to create an independent body that made monetary policy without direct presidential control.
Of course, 3 of the 5 members were subject to presidential dismissal. So the Sinking Fund Commission is not that great an example of an independent body. There were 2 officials on it who were not. And I just note that this is a very interesting example and important for us to think through. But it isn't just about the removal power, because on that commission were the Chief Justice of the United States and the Vice President, and the Chief Justice would not be a a member of an ordinary regulatory commission. So I think what we would find is that in terms of 18th century categories, that this probably would not be regarded as regulatory power, executive power on the part of the president. But I still think that Christine's work is very directly relevant to this, and that there are originalist examples that we need to feed on. I think the more conspicuous originalist precedents for the open market operations, the central bank operations of the Federal Reserve, is actually the first and second banks of the United States. The first Bank of the United States was created again by Alexander Hamilton in the first Congress, enacted by Congress, and it was deliberately structured by Hamilton, and he explains why. Deliberately structured to be outside of political control. It was chartered as a private corporation. There were 25 directors, and they were elected by the shareholders. But interestingly, even though the largest single owner of shares in the first bank was actually the United States, the statute forbade the United States from using its voting power as shareholders to elect directors. So the directors were not only elected by the shareholders, they were elected by the shareholders other than the United States. And what Hamilton explained was that he thought that the government was an unreliable party to be in charge of central bank operations. And the reason for that is, there are a number of reasons. We could tick through them, reasons why independence makes sense. But the principal ones from Hamilton's point of view is that the United States government, like all governments, is a persistent debtor. It borrows money, and debtors have one way to make it easier to pay back your debt is to reduce the value of the currency. So, debauching the currency is this favorite strategy of governments all around the world who are faced with budget problems. And Hamilton didn't want that he wanted a stable currency and believed that the incentives of a private bank were better. And so the president had no authority over that at all. And if those central bank authorities were viewed as private and not under presidential authority, I think we can draw an analogy today to the Federal Open Market Committee, where their activities also are not governmental in the sense of command and control regulation, but instead, much like the first bank of the United States, is a market participant.
I have a book coming out, The Pursuit of Liberty, How Hamilton versus Jefferson Ignited the Lasting Battle Over Power in America. And this is just one more example about how their initial battles over the constitutionality of the bank and private versus public control over monetary and fiscal policy continue to resonate today. Christine, what is your view about the precedential effect of the battles over the bank with regard to the Fed? Does it suggest, as Michael does, that the open market functions of the bank should be considered private and distinguished from the regulatory functions? Or does it justify the constitutionality of the Fed in its current structure?
Yes, and if I could respond to 2 points that Michael made. I think the first one was maybe disagreeing that the sinking fund was, in fact, independent, and he is reiterating a functionalist argument that Justice Alito made in Collins versus Yellen, saying, well, if this commission is controlled by 3 of the 5 members can be removed at will by the president, then perhaps they're going to do what the president wants anyhow. I think that's still a problem from a formalist perspective because you have an independent chief justice and an independent vice president voting on the sinking fund commission's purchases independently of the president, regardless of whether their vote would have a particular effect or not. And the reality is that if there were any person missing from the commission, or as actually happened in 1792, if Hamilton and Jefferson disagreed and you didn't have three people voting in line with a particular view, then it turns out that the independent members of the commission have the controlling vote. So I think there was substantial independence, and especially if you think about its overall structure, that it had to approve any purchases that the president wanted before they could go forward. The president was powerless to initiate a purchase without approval of the Sinking Fund Commission. I think that is truly an independent structure in important ways. So just to kind of clarify that point, and then looking to, should we consider the Bank of the United States as a different precedent to look to on this question? And I think there are very important differences between the Federal Reserve's role today as a central bank, which effectuates public and statutorily defined goals of maximum employment and stable prices, pursuant to discretionary control over the money supply, and the role of the first bank of the United States. And as an originalist, I think I'm focused mostly on the first bank, which is closest in time to something that might shed light on original understanding. So the first bank was, as Michael noted, a private for-profit corporation designed to provide banking services. And it loaned money to the government. It held their deposits. It also loaned money to private parties. But it didn't have a public or statutorily defined mandate to pursue monetary policy in the same form as the Federal Reserve. And I think, in fact, a better analogy perhaps to the Federal Reserve's functions would be that of the Sinking Fund Commission, because the Sinking Fund Commission did have these public goals that were statutorily defined. It was to pay down the debt while supporting U.S. credit, and it effectuated those goals pursuant to open market purchases of debt in the form of U.S. securities, which is one of the historical ways that the Federal Reserve as well effectuated its monetary policies. More recently, it switched to other mechanisms for carrying out monetary policy, but still there are important parallels. So I think it's very difficult to draw this line and say, well, maybe the Federal Reserve's open market functions are just private or quasi-private and don't really count as an exercise of executive power. And in fact, in Justice Alito's decision recently in Collins versus Yellen, he defined executive power as interpreting a law to implement the legislative mandate, and that is the very essence of executive power. And I think that's what the Sinking Fund Commission did, and I think it's what the Federal Reserve is doing today. So it's very hard to have, if you will, a bespoke exception for the Federal Reserve based on the first bank of the United States.
Michael, the important conversation you're both having is whether the Fed has been treated as different and whether monetary policy has been treated differently from the time of the founding. And of course, more broadly, about whether independent agencies are consistent with the original understanding. And Christine is arguing that Alexander Hamilton, the very source of the unitary executive theory, because after all, it was Hamilton and the Pacificus essays who articulated the unitary executive theory. Christine and other historians have argued that Hamilton tolerated complex bodies that were essentially independent. And Christine also notes that in addition to the Sinking Fund Commission, Congress created other commissions outside of executive control, including those that ruled on patents and those already made up of existing officers of the United States. And to this degree, the argument is that even Hamilton himself, the great defender of unitary executive theory, was not averse to creating independent agencies. What are your thoughts on that question?
Well, I'd like to begin with a just sort of global note here that, Christine and I are seemingly disagreeing, but I think actually toward the same end. That is, we both believe that the open market operations of the Fed can be defended on originalist grounds. Now, she finds the analogy to the Sinking Fund the most compelling. I'm inclined to think that the analogy to the First Bank of the United States is the most compelling. But both of us come to the conclusion that the open market operations of the Fed, which are the ones where we were economists really care about independence can be defended. So I think this is an internecine disagreement that we're having here. Now, as to whether any of this is consistent with the unitary executive theory, really depends upon what your definition is of the unitary executive theory. This is just an academic term that has been slapped on a family of arguments that have to do as they have their origin in the first sentence of Article 2, which vests the executive power in a president of the United States. Now, that terminology is not without meaning. We actually know quite a lot about what people thought executive power was, but on the margins, there are some disagreements. There's there's evidence that points in different ways, and it's rather compelling to say that when you look to these things that look to be exceptions to presidential control, that most of them are on these boundaries. It's like we can argue about exactly what kind of, how we would classify the powers that are exercised by some of these commissions. And some of them have to do with, the Patent Commission was run by cabinet people who are already cabinet positions, and again, under presidential control. It is my opinion, and I don't know that this tracks with any of the justices on the Supreme Court, but it's my opinion that the Constitution embodies an incomplete unitary executive theory. That is a not quite completely unitary executive theory, and by that I mean that Congress is entitled under the Necessary and Proper Clause to vest the powers of government in particular officers or agencies. And when the Congress does that, it is that officer or agency that must act. And the question is, can the president control that person? And to know the answer to that, you have to look at the appointments clause, and then we infer removal authority from the nature of the power that has been delegated. But in all cases, it's always incompletely unitary, because when the president makes appointments, which is certainly an important part of control, it's subject, at least of the principal officers, it's always subject to advice and consent of the Senate. So the advice and consent of the Senate was a deliberate check on the ability of the president to be able to name whomever he wanted to the offices that would be carrying out the powers of the government. And thus, from the get-go, and I think in a way which is evident just from the very text of the Constitution, we have an incompletely unitary system. What I think we have is one in which a president can eventually get his way with all things that are of a governmental and regulatory nature, but it's sometimes, he's going to have obstacles along the way. He has to fire people. That's what in Watergate, that's, the Saturday Night Massacre, and when the president has to discharge people in the course of these controversies, as with Lisa Cook today, it raises the question to a higher level of political debate, and brings Congress into bear, and leads, and it entails a political cost to the president to be able to do that. Now, President Trump is less concerned about political costs than most presidents have been, but it's still there.
Christine, is your argument that the Fed is different from other independent agencies because of its unique history in the sinking fund, or that it's structurally similar? In other words, could the Supreme Court do what it suggested it might do, which is overturn the Humphreys executor case, question the constitutionality of many independent agencies but make a Fed exception, or not?
I think there is no particular Fed exception, and I think the Sinking Fund Commission operates at a higher level of generality. And what it shows is that we did not have a unitary executive understanding of Article 2 insofar as the claim is that Article 2 creates an absolute structural rule about the executive branch and that the president must have power to fire all subordinate officers or perhaps all subordinate principal officers at will. The Sinking Fund Commission is a counterexample that disproves that idea and shows that Congress has discretion to create politically insulated structures when it feels it is appropriate to do so. It felt it was appropriate to do so at the founding, not only for the Sinking Fund Commission, but in a number of other examples. So there were also provisions in the statutes that provided that deputy marshals who would step into the role of marshals if they died or otherwise left their office, these deputy marshals would be subject to removal by Article 3 judges, not by the president. Similarly, there were other laws on the books that allowed Article 3 judges to make initial fact-finding determinations on whether or not to adjust or remit the amount of revenue fines that a certain person might owe based on a finding that they didn't violate the revenue laws intentionally. These Article 3 findings were then transmitted to the Secretary of the Treasury, so Alexander Hamilton, Secretary of the Treasury, could make a final determination. So again, that is an Article 3 judge participating in an initial executive fact-finding determination, and they're doing so with the good behavior tenure that Article 3 provides. So I think throughout the early laws, there are plenty of examples of where Congress delegated executive power to persons, officers whom the president could not remove. Additionally, even private prosecutions that were authorized at the founding were things that were granted to private parties, had the ability to sue officers who violated their statutory mandates, to recover certain awards that were specified in the statute, but without personal injury to the people suing. And again, this was a delegation of law enforcement power to prosecute against certain violations of the laws to private parties whom presidents could not remove. So I think there are a lot of examples in the early statutes showing that the first Congress repeatedly handed off executive power to officials whom the president could not remove.
Michael, what do you think history suggests about whether there should be a Fed exception? In the Trump v. Wilcox case recently, the Chief Justice said that the Federal Reserve is a uniquely structured quasi-private entity that follows in the distinct historical tradition of the first and second banks of the United States. And he cited footnote 8 from the Celia Law case. And Justice Kagan thought he was making much too much of that. But do you think the Fed exception can be justified because of the unique historical experience? Or do you think it should be treated like other independent agencies?
I do think that it's an exception. Now, I think that what the Chief Justice said is entirely persuasive, but we do want to think about what the role of history is in constitutional interpretation. So I don't think the brute fact of the predecessors of the Fed, the first and second banks of the United States, I don't think the brute fact of their being set up in a way proves anything. What it does is it is evidence of what kind of a theory of executive power is embodied in the Constitution, and there I think that the missing piece is what kind of power is being exercised. And I think that when the government has an institution set up that is engaged in buying and selling securities in the open market and lending money, that is not the kind of power that the theory underlying executive power theory requires to be vested in the president. It can be vested in a private institution. We have any number of private institutions that exercise powers that might also be exercised by the government. Amtrak, for example, runs a railroad. So I do not think that the Constitution compels all these activities that are sometimes administered in the executive branch necessarily constitutionally requires that they be in the president. And here's the choice, because I don't think there's much doubt that the Supreme Court is moving in the direction of overruling Humphrey's executor. Humphrey's executor never made any sense. It's been, roundly criticized, for decades. I think it's on the chopping block. It's on the way out. And those who want to say that the Federal Reserve is just like any other regulatory agency or what they're buying is a destruction of the independence of the Fed. And I think I thought I was hearing Christine's account of the sinking fund and why she said it's so similar to the central banking operations of the Fed today. I thought that was an argument for why there's a special rule for that kind of operations, that is central bank operations that do involve buying and selling of securities and not command and control regulation of the economy. If that's an exception, then the independence of the Fed will survive. If it's not an exception, then we may be facing a brave new world.
Christine Michael raises the important question of the role of history in liquidating constitutional meaning. And you both have noted Madison's famous observation in Federalist 37, where he says that all new laws, though penned with the greatest technical skill, are considered as more or less obscure and equivocal until their meaning be liquidated and ascertained by a series of particular discussions and adjudications. Madison famously signed the bill creating the second bank in spite of the fact that he had originally maintained in 1791 that the bank was unconstitutional. So Madison changed his mind about the constitutionality of the bank because its meaning had been accepted by subsequent Congresses and by the people. What are your views about liquidation in this case? Does it suggest that, once again, that the Fed is different and Madison came to accept the bank but not other agencies? Or has the constitutionality of all the agencies been liquidated since their constitutionality has been broadly accepted, although not completely so, ever since the Supreme Court upheld it in the 1930s?
Sure. So, I think liquidation as an understanding here might suggest there would have to be argument, debate, and then acceptance of a certain structure as constitutional. And just to be clear, the question about the bank's early constitutionality did not involve executive power. It was a question of whether it was a particular structure that was within Congress's power. And ultimately it was found that it was a means that Congress could use to effectuate other ends. So that was the big original question about the constitutionality of establishing the Bank of the United States, a distinct question than the one here. And one of the striking things about the Sinking Fund Commission is, you might say, it wasn't actually liquidated because there wasn't an argument about whether or not it was constitutional. In fact, Thomas Jefferson despised the Sinking Fund Commission's goals. It essentially operated to prop up and assist the financial markets that Hamilton wanted to support and that Jefferson did not want to support. So he had every reason to object to the Sinking Fund Commission, and he did dissent and object to its policies, but he never suggested that its independent structure was unconstitutional. So it's slightly different in those terms, but I would say that gives it even a stronger claim to something that weighs in favor of an original public meaning, allowing Congress discretion to create that type of independence because it was accepted and implemented without controversy. In fact, it was proposed by the executive branch, then it was adopted by Congress. And it also is a longstanding statutory arrangement that persisted through and beyond the Jefferson administration. So I think it's very solid evidence in those terms. And I think what you've brought up, Jeff, also raises just another question about uses of historical evidence. And I think one of the underlying concerns here might be the need for maybe a historical twin or kind of a close analog to certain structures for them to be considered constitutional today. And I think that type of analysis that's been adopted by the Supreme Court in the Second Amendment context in Bruin, I think it works especially poorly in the structural context because taken to an extreme, you might say, well, for any agency to be constitutional today, it has to have a close or near historical analog in the set of agencies that were adopted by the first Congress. Well, there are, of course, many different agencies today to deal with problems today that we didn't have back then. So the Federal Aviation Administration, for example, is a newer agency that was not a problem faced by the first Congress, and the fact that there wasn't something similar that was developed or created at that time shouldn't be considered a concern constitutionally. And I think some of this exercise of trying to say, well, if the Federal Reserve is okay, we need to say that it has a fairly close historical analog is problematic because there are going to just be many, many agencies that do not have that type of historical analog. And I think originalism should operate at a higher level of generality. We're not looking to these examples to say specifically, are they on all fours with a modern arrangement, but instead to say, what rule did they reflect? What understanding did they reflect? And here, the idea is that if there is no specific textual removal power granted to the president under Article 2, could that be part of an implicit understanding of Article 2? And in this case, ideally, we would know what the public thought. Were there polls saying this is what the public thought about the president's power? Did he have an absolute removal power? There's not evidence of that sort, but I do think this evidence of early practice, especially for the Sinking Fund Commission, where it was, again, a commission that was proposed by the executive branch in Alexander Hamilton, something enacted by the first Congress without congressional objection or objection from other opponents like Thomas Jefferson, and a longstanding statute. I think that is a arrangement that we should pay attention to, and we should look to the broader constitutional rule it suggests. And I think the broader constitutional rule it suggests is that Congress does have the power to create independent structures when it feels it is important to do so. It's a rule of congressional discretion. Now, I do take Michael's point that wouldn't we be better off, at least in a world where the Supreme Court saved the Federal Reserve, as opposed to a world where the Supreme Court ruled that the Federal Reserve and all other independent agencies were unconstitutional. So maybe it's going to stick with the carve-out that it's already created in Celia law and now in Trump versus Wilcox. But I think it's a matter of getting the history right and understanding what the structure was in the founding era. I do think that there is a broader understanding that supports a broader range of independent agencies.
Michael, you have written about liquidation as one of the 5 principal approaches to constitutional interpretation in your piece, Time, Institutions, and Interpretation in the Boston University Law Review in 2015. What is the role of liquidation or longstanding practice when it comes to evaluating the constitutionality of the Fed and of independent agencies more generally?
So I see liquidation as having the same kind of status as precedent, and which is not, it is not as authoritative as actual text. I look at the text, and the text answers some questions, and it leaves some ambiguities. There's some questions, as Madison explained in Federalist 37, where he used the term liquidation. It leaves some questions, and then sometimes the text is illuminated by history, by events such as the ones Christine has been describing. In which case, there we have an answer. And sometimes, even then, we know it's a constitutional question, but we don't know quite what the answer is. And current, modern day judges, rather than just making up an answer for themselves, and liquidation tells them, well, why don't they look to see what answer has been given to that by American institutions over time? And some of those institutions are courts. And so when the courts make the decisions, we call that precedent or stare decisis. And when the institutions that deal with the questions are political institutions, maybe it's Congress, maybe it's debates within the executive, maybe it's in the state legislatures, maybe it's common law decisions, which I think are really in a different category. And when those have been made over time, we should accept those, again, unless they can be shown to be actually wrong. So these are kind of presumptive bases for decision making. Now, I agree with Christine that this idea that you have to look for close twins, like an exact analog for something to be constitutional is a mistake. There's an asymmetry here, though. I do think that when there is a twin, a close analog, and that it was approved, say, by the first Congress, that does mean something. So the fact that the aviation administration may not have a close analog does not make it at all illegitimate, but the fact that the central bank functions of the Fed do have a close analog makes a difference there. Now, if I understood Christine correctly, she takes the view that the president doesn't have any removal authority, no constitutionally vested removal authority at all, that for all regulatory agencies, all agencies carrying out executive power, that Congress can decide for itself how much independence to give them. And I hear that, but it seems to me quite inconsistent with other evidence. So the biggest debate, the most explicit debate over this had to do with the great departments of foreign affairs, treasury, and war. There was a several-week debate, and the conclusion was to draft statutes in such a way that made it clear that the president had an underlying constitutional power to remove these principal officers. And we know why. Because people like Madison said why during the course of the debate. And lots of people on the other side of this too. But the winning side, as articulated by Madison, is that if the president doesn't have the ability to remove these officers, then he is deprived of the executive power. The executive power has effectively been vested in someone other than the president. And the removal power is essential for him to be able to carry out his duty to take care of that the laws be faithfully executed, a duty that is set forth in our Article 2, Section 3. So Christine's position certainly contradicts Madison's. Now, maybe Madison was wrong, but I'm inclined to think Madison was right. And so what I want to do is to look at that as a general principle, that the removal power exists with respect to the great departments of state. And then when there are these other things like the sinking fund or the First Bank of the United States that might appear at first blush to be anomalies, I want to think about them and why Congress might have regarded them as different. That is, these I don't want to use these anomalies as a basis for rejecting the decision that we really do know was made, and we know why it was made, and it was made publicly and loudly and importantly. That I take it to be, I think we should be accepting that, and then see what the boundaries of that decision are by looking at these more anomalous arrangements like the sinking fund.
Christine, any responses you'd like on the question of Madison and liquidation and the sinking fund, and then take up, if you will, this question of the for-cause standard. There are about 20 federal laws, like the ones governing the Fed, that allow the removal of agency leaders for cause. More than 30 laws, including that dealing with the Federal Trade Commission, say that officers can only be removed for some combination of inefficiency, neglect of duty, and malfeasance. Is that difference significant? And does an allegation of mortgage fraud meet the for-cause standard or not?
So if I could first respond to Michael on a few points. And the last thing he said, I believe, is that the Sinking Fund Commission is an anomaly and we shouldn't pay attention to that. But I think that's a problem for the unitary executive theory because it isn't about allowing the president to remove only some executive officers. It's an absolute structural rule in the executive branch that the president must have authority to remove all executive officers at will. So if you have a deviation from that asserted rule for the unitary executive theory, that is a problem for the unitary executive theory. I also do think the decision of 1789, while often cited by unitary theorists as an example in favor of presidential removal power, there are some problems with reading it that strongly. First of all, yes, Madison said things at some points in that debate that were favorable to a unitary understanding, or the idea that executive power included a removal power. But also, he had to change his mind during that debate. He initially started with the proposition that removal would mirror appointments and that the Senate would have to approve any removals by the president, which is the same place Hamilton started out in Federalist number 77. In fact, in Federalist 39, Madison also recognized a variety of tenures of office, term of years, good cause, and removal during pleasure. So I think the idea that that debate gave us a clear answer on what had to be the structure all of the time is an overreading of the decision of 1789. Now, that does not mean that in certain cases, Congress, of course, can decide not to place terms on the end of an office, and that would leave the president free to remove officers at will. And I'd also like to address the point on the take care clause issue in terms of, well, what about an officer that is somehow misbehaving in office? Should that person be allowed to remain in office, notwithstanding the president disliking their behavior, wanting to make sure that they are carrying out the laws in accordance with their statutory mandate? I do think that the take care clause would allow a limited for-cause removal power. And this was something that was also debated during the first Congress. One of my favorite phrases is there no way to suddenly seize the worthless wretch and hurl him from the pinnacle of power? So certainly it was an important idea under the take care theory that the president have some immediate power to get rid of somebody who was violating their statutory mandate. But I don't think that necessarily extends to a rule of at-will removal in all cases. And then just, if you want me now to shift, Jeff, to the statutory question, really, involving the removal of Dr. Lisa Cook, who's a governor of the Federal Reserve Board. So that is a decision that the president made that is one that was made pursuant to the statutory restriction on removal. So the Federal Reserve's tenure protections say they can be removed only for cause. And President Trump's primary argument in this case is that he has identified statutory cause, which allows him to remove Dr. Cook. And the language that was used in the statute is different than other statutory tenure protections. So a different formulation, for example, that's applicable to the Federal Trade Commission would be that commissioners can be removed only for inefficiency, neglect of duty, or malfeasance in office. And that might imply a narrower band of reasons that you could remove someone, or perhaps that the misconduct would have to be something that affects how they carry out their duties in office today, rather than in the case of Cook. This was an allegation of mortgage fraud based on representations that she made before she took office. So that might be something that's not included necessarily by that narrower language on the causes for removal. I think she is arguing that cause in the Federal Reserve statute should be interpreted that narrowly, but they did use different language. I would point out, though, that some of the language in the applicable to the governors of the Federal Reserve is different than removal provisions that would apply to the presidents of the regional banks. The presidents of the regional banks can be removed by the governors. And that language is even more generous. It just says that the governors need to transmit in writing a statement of the cause for removal. So I think in that case, you might have an even wider range of circumstances where a bank president could be removed by the governors, and there might be a question with respect to Trump's firing of Cook. How close is that to the looser standard for firing a bank president? And does cause have any real teeth to it? Is there some type of conduct that he has to show? And in this case, I don't think he's gone so far as to say use a speeding ticket or a parking ticket or that sort of thing to try and assert that's a cause for removing Dr. Cook. But I think there will be questions about how broad his authority is under that statutory provision.
Michael, how are courts likely to evaluate this question of whether or not President Trump had cause to fire Lisa Cook? Would they dig into the question of whether or not for cause includes misconduct before holding office, the difference between the malfeasance and cause standard, and the question of whether the cause is pretextual, as Lisa Cook's lawyers assert, and the argument that she's the victim of a political witch hunt? Will courts examine any of these claims or not?
Well, my guess is that they'll examine the first two and not the third. I mean, I'm just guessing. We don't know. I mean, there isn't any precedent. This has not been litigated before. We're all somewhat at sea. And then, by the way, there is one further argument that I've heard that you and Christine haven't mentioned. So, what about conduct that is before the person takes office? I suppose it's not impossible that would be included. I think it's pretty implausible. I don't really see why someone assuming that there was mortgage fraud, and we don't really know, assuming that there was mortgage fraud, to find out that an officer in charge of an agency that's engaged in that very thing, violated the laws that ordinary Americans have to comply with, strikes me it's just as a matter of common sense to be included. I think if we found out that that someone who was hired to enforce speeding laws, like speeded on 12 different occasions before being hired, we would be rather disturbed by that. I think it's not impossible, but I just think it's rather improbable, and I don't know what the basis for it would be. The question of whether the pretext, it looks pretextual. I mean, it certainly looks like what President Trump objects to is her voting with his appointed chair on monetary policy decisions. But we very rarely in the law look to pretext. In employment, there is a rule for that in employment discrimination law, but almost always in constitutional law, we ask, we simply ask whether the stated reason that has been put forward passes muster. Al Capone was prosecuted for tax fraud. I think that was a pretext, and nobody cares. I think presidents act on the basis of pretextual reasons for all kinds of things. I don't think that's going to be an issue. I think a more fundamental question is whether any procedures needed to be followed, because President Trump did not follow any procedures. And I'm inclined to think the answer is going to be no, that the president is not required to jump through any particular hoops. But a lower down, if we were talking about a lower down position where a person was fired for cause for, let's say, some just ordinary employment, we might very well ask the question, well, were they given a hearing? Was there evidence presented at that hearing? I doubt courts will find that was necessary for presidential removal of a principal officer, but we don't know. Now, is cause broader than malfeasance, inefficiency, and so forth? I wish that it weren't, and that I think that independence for the Fed is an important policy matter, but it does look broader to me. A cause seems to include things other than actual wrongdoing, but we'll see.
Well, it's time for closing thoughts in this excellent discussion. Thank you both for illuminating the history and constitutional issues so well. Christine, first thoughts to you. Is the Federal Reserve consistent with the original understanding of the Constitution? And are independent agencies more generally consistent with the original understanding of the Constitution?
Yes, I think both the Federal Reserve and independent agencies are consistent with the original understanding of the Constitution and the idea that Congress has discretion to create independent, politically sheltered structures when it finds it a good idea to do so. And I do think that some of the Supreme Court's recent decisions applying the unitary executive theory have overread select parts of the historical record, and they have looked back to presidential removal power that prevailed some of the time for the decision of 1789, and they've reached the conclusion that that was something that applied all of the time without considering important historical counterexamples like the Sinking Fund Commission.
Thanks so much to that. Michael, last word to you. Is the Fed and our independent agencies consistent with the Constitution?
Well, I continue to think that the central bank functions of the Fed are quite plausibly not governmental in nature. It's a market participant function, and I think there is a sound precedent in the Bank of the United States and perhaps other things too, that activities of that sort can be conducted by entities that are not under presidential control. I think it is much more difficult to make that argument for the Fed's regulatory activities, and that I think it is not distinguishable from other regulatory agencies, and that's why I hope that Congress will take a look at this and will bifurcate the Fed's responsibilities and treating the central bank functions as being protected from a political control, and the others being under political control. I would just say one more thing. I mean, people like to talk about the unitary executive theory as if it's kind of like gravity or evolution or some other like abstract theory. But what we're really talking about here is how a democratic government works. And our Constitution seems to say that executive power, that's actually using the power of the government against individuals, like threatening to throw them in jail or fine them, like the core of the executive power, at least, is something that should be controlled by folks that we elect. And the notion that Congress could ensure that those functions are carried out by people who were appointed by prior presidents is, I think, it's not just contrary to a theory, it's contrary to the reality of democracy. So when President Trump is out, let's say he's succeeded by, a Democratic president, is that president supposed to keep Trump appointees in important executive positions? I think nobody will want that, at least no Democrats will want that. I think Joe Biden fired something like 15 important high-level posts that the Congress had purported to make independent, and that's because when we elect a president, for better or worse, we expect the government to be under the control of that person, and not people who happen to be in office because they were appointed by prior presidents. Elections are meant to bring change.
Thank you so much, Christine Chabot and Michael McConnell, for a timely, deep, and really great discussion about the history and constitutionality of the Fed. Christine, Michael, thank you so much for joining.
Thank you, Jeff.
Thank you.
This episode was produced by Bill Pollack and Griffin Ritchie. It was engineered by Bill Pollack. Research was provided by Griffin Ritchie, Trey Sullivan, and Tristan Worsham. Friends, I'm so excited that my new book is coming out in October. It's called The Pursuit of Liberty: How Hamilton versus Jefferson Ignited the Lasting Battle Over Power in America. Please pre-order online today, and if you'd like a signed book plate, please write to me at jrosen@constitutioncenter.org. Thanks so much for checking the book out, and can't wait to hear what you think. I'm also so excited that next week we're going to release the new podcast, Pursuit: The Founder's Guide to Happiness. It's so exciting to convene Ken Burns and America's great historians to talk about the ideals of civic virtue that united the founders. It's just so exciting to share with you, and hope you'll enjoy it. Always remember that the National Constitution Center is a private nonprofit. We rely on your generosity, passion, and engagement for all our programming. Please consider donating at constitutioncenter.org/donate. On behalf of the National Constitution Center, I'm Jeffrey Rosen.